name is Melissa Benn. I am presenting, of course, You Don't Know What You Don't Know, which is a very accurate title, I think, in all areas of life, because there's so much that, again, until you come across it, you don't realize it's even there. Our agenda, my legal disclaimer, because I am a lawyer, introduction about me. We're going to briefly hit on ABLE accounts, Medicaid waivers, estate planning, alternatives to guardianship, and then we will deep dive into guardianships and then cover a couple of miscellaneous. My goal is to leave about 10 to 15 minutes at the end for questions, so that's the plan, at least. Legal disclaimer, this is a PowerPoint. This is not specific attorney advice to you in particular. Everyone's situation is different. Every county is different. This is just general legal advice and guidance. The fact that y'all are here listening to me does not create any sort of attorney-client privilege, so you can't tell me something and expect it to stay just between you and I when there's a bunch of other people in here. If there's no attorney-client relationship, please do not talk to someone tonight and say, well, my attorney said, because that's not the case. I try my darndest to include everything in this PowerPoint, or at least touch on everything, but I've missed stuff every time. This is not an exhaustive overview of every option or everything out there for these topics. About me, my email, my work number. I got my Bachelor of Arts in Psychology and English and from A&M in '98. Took a decade or so off to be a mom, and then I went to law school at the ripe old age of 34. I've been practicing 12 years, 13 years. I'm a biological mom, or mom of two. I have 3 step kiddos. I have 2.5 grandkids. We have a bunch of animals, so we wear lots of hats. I spent that 12 years in between A&M and law school running child care centers. So that is what I did. There, in my opinion, quite a bit of overlap between that role and this role, because they're both taking care of families, and that's what my passion is. I have had the honor of doing a guardianship for one of my kiddos that I had in daycare as a lawyer because he turned 18, so I really enjoyed being able to link those two lives. I enjoy baking and reading in my spare time. So, ABLE accounts is our first topic. They qualify for it without affecting Social Security, without affecting their Medicaid, up to a certain amount. So, ABLE stands for Achieving a Better Life Experience. So, the money that is saved in the ABLE account can be used for any qualified disability expenses. And that's anything that's going to help them achieve a better life. So, anyone can put money into the ABLE account. So you can put money in it. The kiddos get money for their birthdays. That can go in there. Christmas gifts. Grandparents can contribute. Anyone can. Eligibility requirements for a Texas ABLE account. You have to be a Texas resident. They have to have been disabled prior to the age of 26. Starting next year, that age will be raised to 46. So probably not an important point for y'all, but you have to be able to prove the disability. So if they're eligible for SSI, physician's diagnosis. I will say the clients I've had that I've chatted with who have opened ABLE accounts, they've, again, small sample, but they've never been called on to provide proof of a medical diagnosis. It's something you fill out. My parents who are guardians who have opened ABLE accounts as guardians have not had to submit guardianship paperwork. So a lot of it's, I think, the honor system, but it is also a possibility that they will ask you to provide medical diagnosis, provide doctor's notes, whatever. You can save, as of 2025, up to $19,000 per year. This is increased a little bit if your kiddo is working. They can make contributions directly deducted from their paycheck, so like an IRA type thing, where it goes directly from their paycheck to the ABLE account, and then you can still deposit. Not that any of us have $19,000 each year to deposit, but if you do, or the grandparents do, they can do that. Lifetime max is $500,000. Up to $100,000 is disregarded. So whereas if you're receiving Social Security, your kiddo can only have $2,000 in their checking account. They can have up to $100,000 in this ABLE account without affecting their Medicaid or Social Security eligibility. And of course, while you're depositing money, you're also using this money. So you get like a little debit card. It's actually a prepaid card. And so even though you have to use it for the qualified disability expenses, you're putting, you have your focus card is what they call it. You put $100 on that, and then you spend it at Walmart. You should keep your receipt in case you need it in the future, but the able people are not going to be looking at what you bought at Walmart to make sure it's really and truly helping their life or that kind of thing. So again, honor system, but you might be called upon at a later point in time. So open for $50, deposit minimum $25. You get that focus card that's reloadable prepaid. Able accounts have a little bit more flexibility than a special needs trust, which I'll cover in a couple of slides. One, in my opinion, drawback of the able account is if your kiddo is getting Medicaid assistance, medical assistance, and your kiddo passes, the state can do a recovery from what's left in their able account for the medical expenses that the state has paid. So, from when you open the able account. So if you open the able account when your kiddo is 55 and they've been getting Medicaid for all those years, it only starts when they're 55. So, and again, ideally you're using the money as you're depositing it and all of those things, just not worrying about the maximum. But that is one, in my opinion, drawback of the able account. Medicaid waivers. How many of y'all in here are on the waiting list for Medicaid waivers? So, do y'all know what numbers you are? No. I had, actually quite handily, a client come in this past week, and on the services, the HCS, she is 118,853 out of 124,002. And on the Texas Home Living, she's 108,032 out of 112,000. So, the waiting list, get that on them early. You have to meet both the financial and functional eligibility when you get to the top of the list. So get on as soon as possible, worry about that later. If you get to the top of the list and you don't qualify, you don't need it, whatever, at least you've done it. It provides opportunities for people to receive cost-effective supports and services in their home, and that's why it's such a long waiting list. It could be personal assistance, it could be therapies, employment supports, it could be family members providing care for their loved ones and getting paid for it. So definitely a list to get on. The ARC of Texas has a page where you can look at the waiting list and all of those things. So again, get on the waiting list now. But my husband's not here, so we're good. Estate planning. Estate planning in two regards. First, I'll talk about it for y'all as parents or grandparents, caregivers, guardians. Setting up your estate planning. So having your will, having a special needs trust set up in your will, so that when you pass, your life insurance or your house or whatever goes into that special needs trust, so your child isn't receiving it directly and messing up their benefits. Because if my child has $1,500 and then I die and they all of a sudden have $100,000, then they're no longer eligible for Social Security. They're no longer eligible for Medicaid because they have anyway, lots of money, more than $2,000. So you want to make it where in your will, the trust is set up so when I die, their share goes into that trust, not to them directly. So it doesn't mess with their benefits. They can still get Social Security, they can still get Medicaid, but your money is helping them live a good life because it's supplementing and supporting what they're doing. You also want to have your own powers of attorney, but I'll talk about powers of attorney on the next slide. As far as your kiddos go, special needs trust. 2 ways, 3 ways this can be done. Our most common is in a will. So, because most of us don't have a bunch of money to fund a special needs trust, so I'm much more valuable dead than I am living. So my money will go into a special needs trust when I die for my child. So I don't need to set it up now and worry about it and manage it, because I don't have anything to put in it. So it's in my will to come into existence once I'm dead. Sometimes parents either have that money, grandparents want to leave, $10,000 to their child, that sort of thing. So we set up a special needs trust now. So it becomes a little financial person walking around. You have to take care of it, but you can put money in there for your child for their benefit. You cannot pay for things that they're getting assistance for. So if they're on HUD, you can't pay for their housing with their special needs trust. But if they're in a medical facility, you could pay for a private room versus a shared room. You can pay for that difference. But you have to be careful with the special needs trust to make sure that you're only using it for those permissible expenses. And that's something when you're setting up a special needs trust, we'll go over what those expenses are. You'll have that information and guidance so you know what you can spend it on, what you can't spend it on. Again, you can set it up before or after death. Special needs trust versus the ABLE account, unlimited amount of assets. There's no restrictions on how much you can put in there 1 year, and there's no restrictions on the max. Your child is only the beneficiary. They never have control over it, and they never have any of that money in their possession, so it doesn't count against them on any kind of the benefits. Again, can't be used for housing or food, assuming your child is getting assistance, government assistance for those things. If they're not getting government assistance for those things, you can use it for those purposes. You can, buy them a house with the special needs trust if you want, as long as they're, again, not getting assistance for those things. Not subject to a judgment. So if, again, Medicaid recovery, when they pass, you name your beneficiaries of that special needs trust. You can have it go to the other kids. You can have it go to your mailman, whoever you want. It doesn't go back to the state of Texas. They can't come after anything that's in there. If there is a judgment from a creditor or something for your child, they can't touch what's in the special needs trust. It's completely protected. There's also an option for a pooled special needs trust. The Arc of Texas is the entity that oversees that in Texas. It is for those of us who want the benefits of the special needs trust but don't really have a bunch of the money or don't want to worry about being in charge of it, maintaining it. The Arc of Texas serves as like a trustee, and you have to go through them to get money and stuff. But they'll do the investing, they pool it, that's the name, with a bunch of other smaller amounts so it grows more, it grows better. And they're the ones that are the trustees, they're the ones that are authorizing the distribution, so you don't have to worry about, is this permissible, is this not permissible, because they'll tell you. ABLE, they don't tell you. If anything, you don't ask permission for certain expenses, so you might be spending it wrong. ABLE doesn't oversee that like the Arc of Texas does. And on the special needs trust also, there are two different kinds. Third-party special needs trust is the most common, and that's me setting up a special needs trust for my child with my money. So if I get into an accident and I win a lawsuit for that accident, but I don't need control of that money, so it becomes a special needs trust as a first party because that's my money. But most of the situations that we encounter, it's a third party special needs trust. Sometimes people will talk about different restrictions and rules, not necessarily making the distinction between if it's a third party or a first party, because first party can disqualify you for some things, can be some look back periods and stuff, so just don't get those confused. Third party, as long as it's your money, it's not going to hurt your kiddo at all on any of that. In your estate planning, besides setting up that special needs trust, naming guardians for your kiddos. Obviously, if your kids are minors, you want to name guardians for them. But oftentimes it's, when we set it up, we'll say, I want my sister and her husband to be guardians for my kiddos if they're underage or if they need a guardian when they're an adult. So it doesn't have to specify that they will need a guardian, because a lot of times we don't know, but it just says, if they do, this is who I want. Guardianships, as we'll discuss, they can be, it's not an automatic thing. Whoever you name in your will doesn't just pop in and become the guardian. But it's good to have names there, because oftentimes we'll see families lovingly fighting over having the right to be the guardian of the kids. My sister versus his brother or whatever. And so it's good to have that, the parents' wishes written down, so that the people that we want have a higher priority. because the court's going to look at, who did she want in charge of her children. So it's good to have that in writing in your will. Again, for y'all, powers of attorney, someone to make your medical decisions if you're unable to. If you have a spouse, you want to make sure you name people other than your spouse, because if we're on a cruise and our ship goes down, but we're still alive. So, but we're in the hospital, so we can't pay our mortgage. Who besides the two of us are going to pay our mortgage? And then also for your modes if you can't, if you're both in that coma together. Those documents are also alternatives to guardianship. When y'all come in for the discussion about a guardianship, one of the first things that we talk about are what are the alternatives, because a guardianship is taking away someone's basic civil rights. I have the right to drive. I have the right to go get a license. I have a right to pick whoever I want to marry. And I lovingly made a right choice for that, but I haven't in the past always. I have the right to vote, good or bad, I do. When you're getting guardianship over someone, you're taking away those rights. Not every time, but because guardianships can be very tailored. But in general, you're taking away my right to vote, my right to decide who I want to marry, my right to decide if I want to live on the left side of the street or the right side of the street. And those are big things. So guardianships can be a very involved process because we are taking away someone's basic rights. Especially some kiddos are very excited to turn 18 and be that adult. And when you're having to talk to them about, oh, hey, you might think you get to do this when you're 18, but unless they're like my kids and they don't want to do anything when they turn 18 because they still want to be kids and have mom take care of them. But that's just mine. So less restrictive alternatives to guardianship. Power of attorney for money. So it's called a statutory durable power of attorney. That's what the initials are for. But it's for your money. So my kiddos turned 18. Of course, I'm a lawyer, so I had them do powers of attorney to give me authority to help them and make financial decisions for them. So they could still do it. They could still go to the bank, but I could do it too. So I could go talk to their bank manager and find out why they withdrew their account again. I could have a power of attorney for their medical, so I can go talk to their doctors, but they can also talk to their doctors. If they're unable to make a decision, I can make it for them, but as long as they can make that decision, they get to make that decision, so I'm not taking away any of their rights. So the court's going to want to make sure we looked at these alternatives before we went straight to taking away all the rights. So, yes?
Can I ask, so how would you do that? We need to hire a lawyer and do that?
I always say,
or how do we do that?
I always advise hiring a lawyer. Powers of attorney, there is a statutory form that I know you can find it online. For your kiddos, because you have to have it notarized. So I know when I have parents come to me for a guardianship, we talk about powers of attorney first. Sometimes we will go that route first, see how it works, and if it doesn't work out well, we'll go to guardianship then. If it's an option, and it doesn't always work out because someone has to have capacity. I have to be able to not understand reading the legal document because no one does that, But if someone explains it to me, hey, do you want to give your mom the opportunity to talk to your doctors and get information from your doctors and stuff? If I can explain it to someone and they're understanding that and can, in my opinion, as the notary, understand what they're signing, then I'll notarize that and they can use that. It probably is something you can do yourself, although I obviously, and think talking to an attorney is important because I've had parents in Montgomery County, because we practice in, I think, like 12 different counties, a bunch of counties. I did a guardianship in Montgomery County once where this girl, she was nonverbal, non-ambulatory, she had a power of attorney. I'm like, the school district told mom, put a pin in her hand, hold her hand, and sign her name on this power of attorney. And of course the court wasn't real happy about that, but that's what the school district, and of course the school district told her, so she did it. And then she actually tried to use the power of attorney somewhere, and they're like, that's not valid. So I think always getting professional advice from someone who legally understands what's going on is a good idea, but it's not required for this. Guardianship, it's required to have an attorney. Powers of attorney, they're a lot less expensive for one, but they're much easier because it's you don't go to court, it's just a document you sign with a notary. So supported decision-making agreement, this one a lot of the schools mess with or do advise, whatever. Because when your kiddo turns 18, for better or worse, they're an adult. Doctors shouldn't be talking to you. education, that's not even a word. Educators should not be talking to you until that child says you can. And so that's where the need for powers of attorney or guardianship arises. Supported decision-making agreement is like a power of attorney light. It just basically says, I get to make all my decisions, but my mom is going to support me in making those decisions. So you can talk to her and give her all the information, but she can't make a decision for me. I get to make the decision. Whereas powers of attorney, mom can make the decision or I can make the decision. So supported decision-making agreement, again, I'm not a huge fan of them because I don't think they have much bite. They don't do much, but they do deal with education, whereas powers of attorney do not. So supported decision-making agreement is great for education because it says that the educators, your art people can talk to your parents, but you're making the decision for yourself. Powers of attorney don't address the educational system. So, and then supports and services. MHMR has a lot of services that parents can utilize. The community-based services for Medicaid. If your child has a caseworker or if they have a social worker that's going to help them with things, can that help in the assistance from the family prevent the need for a guardianship? That could be a less restrictive alternative, just having a bunch of helpers in their family or in their life to not have the guardianship. But again, you have to have the capacity aspect of it. Sometimes we'll have families come to us from where a traumatic brain injury, a perfectly healthy 35-year-old gets into a car wreck and all of a sudden they don't have the mental capacity to consent to medical decisions or pay their mortgage. And that's where if they had these documents, it would have prevented a guardianship. But because they didn't, then we have to go that guardianship route. And so having, as a neurotypical adult, having these documents in place already for yourself is very important and much less expensive than guardianship. Guardianships, I know in this arena, we're focused on kiddos who have some incapacities who are turning into adults. They're 18 years old. Guardianships also come into play a lot with older people, so dementia, mental illnesses, bipolar, schizophrenia, the older people who are aging out of capacity, and then also, of course, your accidents, your traumatic brain injuries. Yes, ma'am.
So the power of attorney, does that mean I'm dealing with a father with dementia and Alzheimer's?
Oh,
so
yes.
Does it mean I just need to carry that in my purse all the time? Is that?
Powers of attorney, having the originals on you can definitely be helpful. And most of your places will take a copy of the original and they all will make a copy of it and give it back to you. So you should keep your original. You shouldn't give that up. With guardianships in the elderly, dementia is always my one example when you can have powers of attorney, but they don't work because I have dementia. You have power of attorney so you can control my finances, but I can still do it. So I can still write the checks to the yard boy for thousands of dollars for planting a plant. And you need a guardianship because you want to stop me from doing that because I'm not knowingly making that choice. Yes, sir.
I always took a folder with me that had all that in there. I was always ready with my dad.
And banks nowadays, especially, for whatever reason, the legislature a couple of sessions ago gave them some more power to reject powers of attorney. So they can be pickier about those nowadays. But I think having your originals on you and just, but there are points in time where you have powers of attorney, but you're still going to need a guardianship because they're fighting you on stuff, or you want them to stay in this facility and they won't. So you need them in memory care and they won't stay there. So that's when guardianships come into play for the older folks.
So with a child,
Mm-hmm.
does it kick in? You may be fixing to answer it at 18, or does it kick in at 21?
It only
If they're
kicks in.
developmentally disabled.
Everyone becomes a legal adult at 18 years old. On their 18th birthday, everyone is a legal adult. And whether or not a guardianship doesn't kick in until we go to court.
But so you need a power of attorney.
If they can execute one, if they have the capacity to execute it. So, if they have the capacity to execute it, we can try that first. Again, sometimes I'll have parents come to me, they think they might need a guardianship, not sure, and we try the powers of attorney, because a lot of times the concern is my child can do a lot of these things, but they're also very susceptible to being taken advantage of,
Right.
and they can sign a contract for a new car that their friend's getting, and then they're legally on the hook. So can we try powers of attorney to give them the most freedom, and then if they're signing contracts left and right, then we want to go to the guardianship route to take away their right to do the contracts. But sometimes powers of attorney aren't even on the table. Like, we're not looking at that at all, because they don't have capacity. They will never have the capacity to execute that document. Yes, ma'am.
So my daughter will be 18 in May.
Mm-hmm.
How in advance, how soon should I go ahead and?
17 and a half. I don't know if I actually have that. 17 and a half is when we begin the guardianship process. Ideally, there's no rule on it's never too late to do a guardianship. I've done them for 50-year-olds. So there's not a cap. But 17 and a half, we can get the process completed, with the exception of the hearing, before the 18th birthday. The court will not give us a hearing until they're 18 years old, because before that, you're still their parent. You still get to do everything. So usually we'll get a hearing. Like I have a kiddo who turned 18 this week. We have a hearing next Thursday for that. That was the closest we could get. So we get everything in place, and then we have the hearing. So it enables you to keep being the parent after your child turns 18. Very specifically tailored. Very rarely is there a blanket guardianship over everything. Some situations that's appropriate, because the child can't really do anything for themselves. Oftentimes they'll retain the right to vote. They might, retain the right to do their ADLs. They might retain the right to make medical decisions that aren't invasive. But if it's an invasive procedure, the guardian gets to decide that. I've had them where the ward, which is your child, the person who's under the guardianship, is called a ward. They can drive, but only in Brazos County. And then we loosened it up to Brazos and surrounding counties, but they had to be home by 10. So we try to make it as broad as possible so your child can do as much on their own as they can. It does put the responsibility of your child back onto you, but you have to wear a different hat. If, my child's 16 and a half, going on 40, but she's 16, and if she doesn't want to go to church, I'm her mom, actually her stepmom, but I can tell her to go to church. Get up, we're going to church. If she is 19 years old and I'm her guardian, I can't tell her to go to church, because she's an adult. I have to take her preferences into account, because I'm her guardian. So I have to look more at what she wants when it's one of those things she can decide. If it's surgery and she needs it, I don't care if she doesn't want it. That's medically in her best interest. But things like, she really wants a female doctor versus a male doctor. I need to find a female doctor. I can't just pick the male because he's handy. So you have to take into consideration things you wouldn't necessarily as a parent when you're a guardian. So you're just wearing a different hat. Within 6 months of their 18th birthday, so 17 and a half. It's one big process as far as we get an application, we fill out the paperwork, you do a training. Actually, this is a slide. Healthcare provider certificate of medical examination, which I have a copy of on the next slide. So you get that from the doctor. We fill out our application based on what the doctor says. We have to have your child served from a constable, which can be scary. They're really good. They set it up with you typically, so you know what's happening. You can be there with your child. It doesn't matter if your child can't hold paper. They will set it in their lap. They have to physically serve your child. No common sense, but that's it. As a guardian, a potential guardian, you have to register the guardianship online. Based on that information, they do a background check on you to make sure you're not a felon, to make sure you don't, you're not a person of ill repute or something like that. You have to do a training, hour-long training, following this little man through life, going over all the duties as a guardian. So from that, you get a little certificate, and we file that with the court. Bill of Rights, that's just a piece of paper that says, if your guardianship, these are all the things you can keep doing unless the court says you can't. So this is what the Bill of Rights looks like. And it just says, unless limited by a court, you get to see a doctor. And it just tells them all the things you still get to keep doing. You still get to keep communicating your wishes. Your guardian has to listen to those to the extent that they can. And then attorney ad litem is appointed to represent your child. So again, even if your child can't communicate, they get an attorney. That attorney just says, we're not opposed, because that's all they can do. Again, one of those areas, in my opinion, it doesn't make sense for another attorney to be involved, because we cause enough trouble on our own without having two of us. But that's a requirement. Sometimes cases will happen where we need a guardian ad litem, which is a best interest situation. I'm a guardian ad litem in a couple of cases now. One young lady, she's 76, but she was getting evicted, and she doesn't want a guardian. She does not want a guardian. She'd rather be homeless. Obviously, my position is she needs a guardian. Her attorney is fighting for her not to have a guardian because that's his job, but she needs a guardian. She has 11 dogs, big mess. But anyway, my position as her guardian ad litem is this is their best interest. That's what my argument is. This is page 2 of the healthcare provider's certificate. If you email me and let me know you want a copy of that, I can email it to you. Brazos County's is a little bit different than all the other counties. It's a state-specific form, but Brazos County has tweaked theirs to make it more fun. And it changes, like it's changed, the past 4 years has probably changed 3 times. Not drastically, but it has changed. So the biggest thing, it's 4 pages, so it's not the only things, but these are the bigger things the court's looking at. Are they oriented to person, place, time, and situation? Do they know what year? Do they know who you are? If I introduce myself and ask them again in 10 minutes, will they know who I am? Do they understand, they're at the doctor's office to get evaluated for something? Do they have deficits, long-term memory, short-term memory, reasoning logically, grasping abstract aspects? So medical, they know they've been told about a surgery, but they don't want it because they don't understand, because they don't want, all that stuff. I'm running out of time. Do their periods of impairment differ in frequency, duration? That's more of an Alzheimer's thing. Mornings are better than evenings. This is the responsible decision. Can they make complex business decisions? Can they execute a medical power of attorney? This is where Brazos County differs. They have now attached powers of attorney, blanket ones, to their document. So a typical certificate is 4 pages. Brazos County's is 17, because they attached, because doctors are doctors and they have their fields, and we're lawyers and we have our fields. And doctors sometimes give conflicting information on these things. And if they knew what a power of attorney looked like, they could more accurately say, yes, someone can execute this. And so Brazos County helpfully attached them so the doctors can look at it and say, oh yes, Johnny can sign that. So these are specific to Brazos County. Can your child manage a personal bank account? If yes, should they be limited? I have guardianships where the person can manage $200 a month on their own. Everything above that, their guardian is in charge of. I've had it where it's only $50 a month. I've had $500, so it can vary very specifically to your child. Can they operate a motor vehicle, public election, have a gun? Again, big civil liberties that we're taking away possibly. So that's why it is such a big thing. Consenting to medical and dental treatment, consenting to psychological and psychiatric treatments. Those, again, big things. So that's why we get that filled out before we ever start our application, because our application is very specific. Yes, ma'am.
So I used to work in the school, and I just felt like students that were significantly disabled and I would ask the parent, did you get guardianship? They had never done it, but they're still taking their kid to the doctor, and the doctor just so the doctors don't say, I'm sorry, because that would be so ugly to say.
Right.
I'm sorry, you don't have guardianship. I'm not going to talk to you, even though your child can't talk.
Right.
So it's in the parent's best interest to do it, just for if an instance comes up.
Yes.
But no one's going to, unless they're a real jerk, will
yes.
really enforce it.
I have clients, again, the 56-year-old that I was working with. Up to that point, his parents had been taking care of him. Doctors never questioned parents. Parents passed away. Sister can't take him to the doctor. No one knows who sister is. Sister had to get guardianship. I've had parents where, again, they're 19, 20. It's obvious. They're going to that pediatrician until they're 21 years old. As I learned this morning, so they keep going to the doctor they've always seen. All of a sudden they have to go to the emergency room and they're over in Montgomery County. That doctor's not talking to them. But you also might get the other doctor if you go the next day and they'll talk to them because they're nice. So it's one of those where legal and common sense don't always necessarily make sense, but legally those people can refuse to talk to the parents. Should they? Probably not. But it might not happen. Your child might be 19, 20, you're never asked. 21 might hit and all of a sudden everyone's giving you, and we can do temporary guardianships, fast track it within 10 days, but of course it's costing you at least double because we're having to do emergency stuff. But sometimes situations arise where we have to do that. So it's, of course, in my opinion, better to get it when your child turns 18, then you have it in place. You don't have to worry about it. You always have that legal authority. If you're traveling out of state, it might come up, you never know. So, but yeah, sometimes people just keep talking to parents and don't ever bring it up, but legally it should happen, but fortunately it doesn't always happen. Again, in Brazos County, you're going to meet with the court investigator. She'll come out, meet with your child. We'll have a hearing. It usually takes about 15-20 minutes. No, nothing really spectacular. We just ask a bunch of questions about things we've already talked about. You have to do your oath. I promise to be a really good guardian to my child. You have to post a bond. In Brazos County, that is a $13,000 corporate surety bond, which means in most bonding companies, you're going to pay about $100 $100 a year to maintain this bond. And there's also a newer company that does a lifetime bond for $300, so much better alternative. Bonds vary greatly by county. Some counties require just a signature bond where you don't have to put up any money. Some counties require $50. Brazos County chooses to do this bond. It's within their discretion, but if you live in another county or go to another county, it will be different. Every year the court is going to visit you, court investigator, not the court itself. So you're going to have to chat with them every year, and then you're going to file an annual report. In theory, you have that guardianship hearing when they're 18 years old. You never return to the courtroom. You're done with the court. You're just going along, filing your annual report every year saying, my child went to, Dr. Chapman twice this year. He saw Dr. Black for dental visits every 6 months. We go to church, we do movies and swimming with Special Olympics. These are our activities. We have, a caseworker through MHMR, and everything's good. And you send that to the court sends you your little approval letter, and then you go to the next year. So it should just run, again, in theory, seamlessly year to year. If your child is higher functioning, the court will probably want to look at things again in a few years, especially, this is stereotyping, especially boys who are turning 18 because they take a little bit longer to mature. So I've had two that by the time they were 25, the guardianship either was over or very, very limited because they had matured so much in those 7 years. So a lot of maturity goes on there. So if your child is a higher functioning, the court's going to want to visit it again. Probably not a whole new hearing, probably just a new letter from the doctor in a few years, but that's a possibility. And that's where the modification comes in. And there are time frames, like on the report from the doctor. That's why we don't start it till we're 17 and a half, because it can't be, like we file our application, but the letter from the doctor has to be less than 4 months old. So that's why we can't do too many things ahead of time, because we're limited. Duties of guardian of the person. We talked about all these, keep doing, making sure they go to the doctor, making sure they're out and about in the community. You can't just keep your child at home facing the wall and not doing anything. They need to be involved in things, especially nowadays when there's so much online. Even if, because some of our kiddos don't like social situations. They would be perfectly happy to stay home and never go out anywhere. But as much as you can, as a guardian, you need to make sure they're socialized, whether it's interacting online with a game or just having people come into your home, but doing something to get them where they're not isolated, because the court hates that. You're responsible for deciding where they live, and you have to update the court about major life changes. I have a client who they go to Mexico for a month every summer, so we notify the court, hey, they're out of the country for a month, they'll be back. If you move, you want to make sure you transfer your guardianship to the other county or the other state. It doesn't have to be redone, but you have to transfer. If you're co-guardians and there's a divorce, you have to notify the court so the court can decide, is that going to continue or we need to make changes? So major life changes we're updating the court on. Miscellaneous, we have an amazing community, as y'all know. So utilize it and all it has. Preparing for the future, doing it when they're 18 versus 56, it's just good to have things in place, because it hurts when people come to you when it's either too late to do something, or it's going to cost them so much. And yeah, when they could have did it a year ago, and it would have been so much easier and so much less expensive, and that's hard to handle. They talked about the ARD and the IEP, social media. I know even in the community resource guide, there's one of the Facebook groups that I belong to. A lot of Facebook groups for our community to be involved in and a part of, because again, you don't know what you don't know. And then of course there's tons of stuff I forgot, but I don't know what that is. So any other questions at the end? Oh yeah, the survey. We're supposed to complete the survey before you leave today, so they can get their funding and how everyone did. Questions? Again, I talk really fast.
Isn't there something like Lone Star Legal Aid?
There is Lone Star Legal Aid. Lone Star Legal Aid for lower income families. They do provide support. I will tell people when I meet with them if they qualify for Lone Star Legal Aid, because Lone Star doesn't always have. For one, they have a huge. People are always like, oh, there's a waiting list. There's a waiting list for family law. There's not typically a waiting list for guardianships. So you might, everyone in the legal world, there's always a waiting list. But not for guardianships. And I'll tell people, if you go to Lone Star and they don't have a guardianship attorney available, call me. I will contact them and let them know I can do it if I'm in that time where I can. I can't always do it, but if I can, I will definitely accept it. So because they don't always have. But yeah, Lone Star Legal Aid. And there's guardianships in Texas, in Brazos County especially, you have to have an attorney, because you're not really representing yourself, you're representing your child, because you're doing a legal action on their behalf, and you're not a lawyer. Well, you might be, but so if you are, you can represent your child. But anyway, you have to have a lawyer involved. It's a very intensive process, a lot of hoops and things to know about, so I always think it's better to have a lawyer involved, especially a lawyer in that community. So if you're in Leon County, having a lawyer, I actually just did one in Leon County, it's not that complicated, but anyway, if you're in Duval County, it might be better to have a Duval County attorney, because they know those judges and what they want. And we don't have to stay involved. We get you through that first year. You can be on your own if you want. We don't have to stay involved. But I usually check in on people and stuff. But you don't have to keep paying, after you get over that first initial cost. And guardianship versus power of attorney, and I know I'm done. Powers of attorney, you're looking at less than $500 for sure. Guardianships, you're looking at least $3,000. So that's why we like to explore powers of attorney if they're even a possible option, just to avoid having a court in your life for the rest of your child's life and having to spend all that money. Because again, you have two attorneys involved, so we're expensive people to know. Okay, any other questions?
Okay, let's give her a hand.